Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we are revisiting the Tata issue. In fact, it all started one quiet Sunday afternoon. People were busy celebrating Akshat Tritiya, and suddenly all of us began to receive emails. These are not emails that we received, they actually went to the trustees of the Tata Trusts. All the senior functionaries, we got copies. And these mails were not sent just to senior functionaries of the Tata Trusts, but also to the Charity Commissioner of Maharashtra. And it suddenly triggered a fresh escalation over the trusteeship issue, which, as many of you who've been watching this video blog know, that we have covered from time to time. There's a succession battle of sorts on under the surface at the Tata Group. Tata Sons continues to have the same chairman. Noel Tata, after some below the surface skirmishes, became the chairman of the Tata Trusts. The Tata Trusts control 66% of Tata Sons, and Tata Sons is the holding company of this US dollar 180 billion group. More importantly, it's, I would say, the bluest of blue chip groups in India. So, what happens at the Tatas, which is seen as a byword of trust and confidence, public confidence, is important to all of us because it's a reflection on India's business environment, and which is why we discuss it from time to time. So, what is going on is ever since Mr. Ratan Tata passed away, nobody is quite clear who is fully in charge, and there are issues. There is a fractious power struggle within the group. The latest is a set of emails by Katyani Agarwal of SV and Company. These are all identical messages she sent to key trustees and the charity commissioner, like I said earlier. All this was done on behalf of Justice T. Raja. Who is Justice T. Raja? He is the former acting Chief Justice of the Madras High Court. Now, where does he come in? He has written these letters through the lawyer demanding immediate regulatory intervention by convening an urgent board meeting at each of these trusts to rectify what he says are violations of Section 38(2) of the Maharashtra Public Trusts Act 1950. This is again important because this act was amended only last year. The demand from Justice Raja was backed by a 19-page legal opinion. This legal opinion, in turn, comes from a Supreme Court Justice, former Supreme Court Justice, Krishna Murari. The judge says that the Sir Ratan Tata Trust, SRTT, which is the biggest of the 5 Tata Trusts that are part of what we call Tata Trusts, is operating in breach of the law. According to Justice Murari, the practice of declaring certain individuals as trustees for life was mere usage. It has no statutory authorization, and now it falls foul of changes in the Maharashtra Act. This large trust, SRTT or Sir Ratan Tata Trust, has 6 trustees on the board. They include 3 lifetime trustees, which is 50%. Jimmy N. Tata, appointed in 1989, Jahangir H.C. Jahangir, and Noel N. Tata, appointed in 2019. Now, this number is double the statutory ceiling under the recent amendment. So, the recent amendment says not more than 1/4 can be lifetime trustees. Okay. So, in this case, it would be a maximum of 1. You can have a little more than 1 if you're going to be really sticky about 25%, but naturally it's 1. Now, Sir Ratan Tata Trust was formed on the basis of Sir Ratan Tata's will of 1919 and a codicil afterwards, which has no overriding provision. So, Justice Murari's opinion says the current composition violates this 2025 amendment, which puts this 25% cap, and it must be rectified immediately by reducing the number of lifetime trustees from 3 to 1. The Charity Commissioner has been asked to order an inquiry, remove the excess trustees, and pass orders necessary to restore legality. If you don't want an order from the Charity Commissioner, the option is that the Tata Trusts will hold their own meetings and decide to follow the law. Failure to act, says this lawyer's letter, will erode public confidence. I don't know if it will, but that's what the letter says. Now, what is the implication of this letter and what are the challenges? Remember, this is the first time that the storied blue chip Tata Group, credited with exceptionally high governance standards, has faced such a direct legal challenge on trustee composition. And remember, opinions are from a former Supreme Court judge and a former acting Chief Justice of the Madras High Court. So there is a bit of gravitas over there. Earlier, Melly Mistry, a former trustee, close confidant, and beneficiary of the late Ratan Tata's will, had made a similar complaint about appointments of non Parsi trustees, in specific Venu Srinivasan and Vijay Singh, to the Bai Hirabai Jamshedji Tata Navsari Charitable Institution. We wrote about it earlier, we talked about it, but many of us dismissed it as a personal grudge or pique because he was voted out in 2025 because of lack of unanimity over his reappointment, and these three, Noel, Tata, Vijay Singh, and Venu Srinivasan, primarily voted against him. So nobody paid attention then, but this time the players asking questions are different. They're coming from people in the judiciary, though they are third parties. So I sent a WhatsApp message to Justice Raja asking how an unconnected party can intervene on this. He sent me a WhatsApp reply which said, and I'm quoting, the purpose of this effort is to prompt voluntary compliance of the provisions of the Maharashtra Public Trust Act, more importantly, Section 30A2, failing which the laudable object of the Sir Ratan Tata Trust will be hijacked by anyone. Resultantly, the Charity Commissioner can exercise suo motu powers conferred under Section 55, 2 and 3 of the Act. His contention is that even a third party can bring to the notice of the Charity Commissioner by virtue of Section 41B and 41D of the Act, and hence his representation is legally maintainable. Now, the Justice Raja's intervention is curious, but the real story is deeper. Enforcing this amendment will reset how the Tata Trust function. The amendment creates two categories: one, tenured trustees with a 5-year term, which is renewable only by unanimous vote. Remember, that is how Melly Vistry was out, because he didn't have a unanimous vote, not a majority vote. And then there are these perpetual or lifetime trustees, which under the Act is capped at 25% of the board. This means that one person can remain a lifetime trustee, and while this will not disrupt day to day operations, Noel Tata, as chairman, may have to revert from being lifetime trustee to tenure trustee, unless the other two are willing to step down and allow him to continue. We don't know. It can play out any which way. But if Noel Tata steps down and becomes a tenured trustee, then he will have to seek unanimous re election every 5 years. Now, given the internal skirmishes, that could be a problem, and the fact of his stepping down itself is a little embarrassing, and it seems like it's aimed at weakening the narrative of a Tata family anchor at the head of the Tata Group. It also means that a single dissenting trustee could potentially remove him as a trustee itself. Doesn't matter that he is Ratan Tata's half brother. This is surely an odd situation. Now, the 2025 Maharashtra Amendment Act was introduced precisely to address concerns that too many lifetime trustees in a public charitable trust means that they control vast assets, and it becomes a quasi private fiefdom with concentrated power in a small self perpetuating group. That may be as it is and correct. But when the money is not coming from donations, it comes from a particular group. I don't know, the situation ought to be different. Global best practices and foundations favor term limits to safeguard the public character of trusts. Even in India, contemporary vehicles of philanthropy, there are many big businessmen who have set up large trusts: the Infosys Foundation, the Azim Premji Trust, Shiv Nadar Foundation, Rohini Nilikani Philanthropies. They have all adopted a flexible, family influenced professional board with natural rotation, thus avoiding the rigid lifetime model of the Tata Trusts inherited from 1919. Tata Trusts are also different. They are the only ones who can hold shares in a business enterprise. That's why they hold 66% in Tata Sons. This has also been controversial. Now, the question is, would any of these business families who have put in only their money, they're not looking at outside donations, would they be willing to relinquish family influence as we are now expecting from the Tatas? I'm sure not. After all, it is their money that is committed, large chunks of their wealth, and they want to direct it in a particular way. So, them having control makes sense, and it's unfair to expect that they will have no say on the spending when they are moving their money, significant wealth, some want to give half, some want to give big chunks of it to charity. There may also be a question that determines future action and litigation in this issue, because it is certainly a question. Meanwhile, in response to Melly Mystery's allegations, the trustees of the Bhai Hirabai Jamshedji Tata Trust have already decided to adopt proceedings before the appropriate authority for alteration of restrictive clauses in respect of eligibility of trustees, says a media report. What it really means is that they are going to look at legal opinion and fight it out to say non-Parsis should be allowed to remain. Same thing can happen over here. But a senior Tata trustee, speaking of the record, pointed out that the legal amendment is non negotiable and tenures can be renewed any number of times. Yes, true. In his view, I think it's good not to have more than one life trustee, or none for that matter. But we don't know. It's a diffuse situation because we don't know who is going to finally control the group. Because, in case of the Tata Trusts, he who controls the trust controls Tata Sons and controls the Tatas as a group and whether it stays together. Now, the timing of Justice Raja's intervention, given this background, is quite intriguing and it adds to the uncertainty. It also comes at a time when Noel Tata himself has raised serious questions as a condition for N. Chandrasekaran's third term as chairman of Tata Sons. You may remember that Mr. Noel Tata has raised the issue of widening losses at Tata Sons, especially the losses of Air India, which alone have gone up to 22,000 crore in FY 25-26, which is far higher than the internal estimate of 1.6 billion earlier. The combined losses of Tata Sons' new ventures are now projected at 29,000 crore this year, which is 5 times the original forecast. These ballooning losses, primarily from Air India and Tata Digital, have certainly rattled the Tata Trust because their income and their charity and their donations are a result of the dividends and earnings that they get from the Tata companies via Tata Sons. And TCS, which has been a star performer, is facing all kinds of issues, including the impact of AI. Now, Noel Tata has demanded a clear turnaround strategy for the bleeding businesses. He has opposed raising fresh debt. In fact, they went private on that basis. And he wanted a firm commitment that Tata Sons would remain unlisted. That also is an issue because, in fact, it's an issue that seems to have isolated Noel Tata and maybe out of the group's hands, not even in Mr. Chandrasekaran's hands, because the Reserve Bank of India has a draft amendment put out on April 10th or 11th on non-banking finance companies. Here again, it has listed Tata Sons as an upper layer NBFC. Now, these upper layer NBFCs, there are just 10 of them, they require mandatory listing. Tata Sons had hoped to dodge this by going private, by removing all its loans and borrowings and maybe also guarantees. And it remains to be seen if the central bank accepts it. They have not got listed while everybody else in the upper layer list has got listed, and they're waiting for RBI to probably crack the whip and give them clear directions. That has not happened as yet. But given that this list has come out only on the 10th of April, it may be out of their hands. There's also the matter of working out an amicable settlement with the Mistry family. Remember, they hold an 18% stake in Tata Sons. They are the single largest shareholder group and they are clearly unhappy, have gone public repeatedly, and want to encash value in their shares. So, by demanding that they stay private and creating problems for this group is not a recipe for any kind of amicability. And remember, the Shapurji group is closely related to Noel Tata through his wife. I've said this before in previous blogs. So, where does this take us? It remains to be seen how it moves, whether Tata Trusts and Tata Sons opt for credible reform, stability, an amicable settlement of differences, or embroiled in internal turmoil in the middle of a difficult global situation for all businesses. The famous governance premium enjoyed by the Tatas for over a century will be seriously tested depending on how they behave in the coming days. I see a lot of litigations, but I hope that they sit together, good sense prevails, and the group remains united and together because that would be good for India. Thank you. If you like what I say, do share.